Hey guys, David Tarras, head of the Federal Criminal Defense Practice at the Rossen Law Firm. What we're going to talk about today is when is the right time to hire a federal criminal defense attorney? Right, and what we're going to focus on here is the investigation stage, as we refer to it, of a federal criminal matter. So, of course, if you were ever to be arrested for a case, we would advise that you absolutely reach out to an experienced federal criminal defense attorney like the attorneys at the Rossen Law Firm to help you with your case. But what about before the arrest or before the grand jury indictment, before charges come? Super, super important part of the case as well, perhaps the most important part and the most effective we can be in changing the overall outcome can be before the charges are even brought. Investigations start in a variety of ways, at least how we define an investigation, right? The government is going to define investigation as them looking into using the different agencies in the Department of Justice with the help of an assistant United States attorney or DOJ trial attorney, them trying to find evidence of a crime and put together their case to present to a grand jury. But our clients become aware, and we as their representatives become aware of the investigation in different ways. Sometimes a search warrant is executed at our client's home or at their business or on their property, and their devices might be taken. Now, of course, if a search warrant is executed at your home or at your place of business or a loved one's home or place of business, that is a great indication that you're under federal investigation and you do want to contact us at that time. Maybe a search warrant isn't executed and your house isn't raided or your business isn't raided, but you get a knock on your door from a federal agent who wants to just have a voluntary conversation with you. Very often they're going to say to you, "You're not under investigation. We're not aware of any crime, but we have a situation that we just want to talk to you about to get your side of the story." Not true. Okay, you are under investigation if that's the case. Even if you may very well just be a witness to a crime, which doesn't mean that you saw a crime with your own eyes, but that you have information about federal criminal conduct. Still, you are involved in part of an investigation. You need an experienced criminal defense attorney to determine whether or not you are truly just a witness or you might have some criminal exposure yourself. So if they do come to have a voluntary conversation, a federal agent from many different agencies, it could be Human Health Services in a healthcare fraud case, it could be the FBI, it could be alcohol, tobacco, firearms, ATF, DEA, IRS, SEC, whoever it might be, you need to contact an attorney. You do not want to give up your most fundamental right of remaining silent and not providing information that might incriminate you, whether it's in the form of documents, spoken statements, or any other form of information that could put you in a worse scenario. The federal agents, if they come to you like friends, they're not your friends. They're also not going to be offended. Promise you, they're not going to be offended if you ask to have an attorney. They might act like they are, but in reality, it can very much help facilitate their investigation while at the same time protecting your rights. So don't have a voluntary conversation with them. You don't know how it's going to be used against you. Contact an experienced federal criminal defense attorney, even if they just come to your door trying to come as friends, or you have a phone call or voicemail on the phone that says, "Hey, we're just trying to talk to you about a case." Don't buy it, contact us, okay? The other major form, I would say, of being put on notice, such as a search warrant, attempt at a voluntary conversation at your place of business or you're over the phone or at your home, is another concept known as a target letter. We'll discuss that in another video, but the target letter does officially put you on notice that you are the subject of you are the target of a grand jury investigation, and that means that they're very along. They're far into the process of the investigation. You may also receive a grand jury subpoena. Your business might be subpoenaed. The custodian of records of your business might be subpoenaed to either appear in front of a grand jury on a certain date to provide testimony or to provide documentation. Grand jury subpoenas, we will have another video on that, but that can be one of the most difficult and nuanced areas to handle without a very experienced federal criminal defense attorney, because the law regarding subpoenas, what you have to give, what you don't have to give, what you have to say, what you don't have to say, is very nuanced, especially if they subpoena your company or the custodian of your company versus you yourself, which is commonly a way that the Department of Justice will, a tool that they'll use to attempt to get documents from you, to get testimony from you, without also violating your Fifth Amendment rights by making you speak to them. You need an experienced criminal defense attorney if you receive a grand jury subpoena, if a search warrant is executed, if they just call you to talk as friends, or certainly if you receive a target letter from the federal government. If any of these things happen, or if you have any other reason whatsoever to believe that you might be under investigation, even if no one has contacted you from the federal government yet, please do not hesitate to call the Rossen Law Firm. We can have a free session consultation on how we can help you navigate that federal criminal investigation process. Thanks.